Hello, in this session I will be discussing the vicarious liability of the state. The state is a legal entity and not a living person. It has to act through human agency, that is through its servants and employees. So, the question arises how far the state will be liable for the tortious acts of its servants. The objectives of this session are basically to understand the doctrine of vicarious liability, study the extent of liability of state for the acts done by its employees, and highlight the changing trends in judicial interpretation in India, widening the scope of liability. What is vicarious liability? Vicarious liability deals with cases where one person is liable for the acts of another. So, in cases of vicarious liability, both the person at whose behest the act is done as well as the person who does the act are liable. It is a form of strict secondary liability that arises under the common law doctrine of agency known as respondent superior, which means the responsibility of the superior for the acts of their subordinate. Liability is placed not on the tortfeasor, but rather on someone who is supposed to have control over the tortfeasor. The common form of vicarious liability that we come across is the liability arising out of master-servant relationship. The principle says that master is jointly and severally liable for any tort committed by his servant while acting in the course of his employment. In order that the doctrine of vicarious liability may apply, the conditions that need to be fulfilled are: firstly, the relationship of master and servant must exist between the defendant and the person committing the wrong complained of. Secondly, the servant must, in committing the wrong, have been acting in the course of his employment. Now, let us examine how far the rule of vicarious liability is applied against the government. In the modern social welfare state, there has been tremendous increase in governmental activity. The state pervades every aspect of human life, like running buses, railways, industries, maintenance of hospitals, slum clearance, sewage disposal, and many such functions. Administrators who are executors of this policy may at times commit wrongs in discharge of these duties. Now, can the government as an employer be sued for such torts committed by these employees? Under the English common law, the maxim was the king can do no wrong, and therefore, the king was not liable for wrongs of his servants committed by them in course of their employment. However, with the increasing functions of the state, the Crown Proceeding Act has been passed in England. Now, the Crown is liable for a tort committed by his servants just like a private individual. The principle evolved by the law is that where a servant of the Crown commits a tort, in course of his employment, the servant and the Crown are jointly and severally liable. But the extent of vicarious liability imposed by law is not absolute because of the exemption clauses. Similarly, in America, the Federal Tort Claims Act 1946 provides the principles which substantially decide the question of liability of the state. In India, there is no legislation relating to government liability in torts. The only provision is Article 300 of Indian Constitution, which imposes the same liability on the union and state as that was the liability of dominion and provinces before enactment of Constitution. Before the Constitution, there was a chain of enactments which ultimately made the liability same as that of East India Company before passing of Government of India Act 1858. Section 65 of the 1858 Act provides that while dealing with the scope of liability of the Secretary of State of India, merely stipulates that the scope of liability of Secretary would be same as that of East India Company. The above provision does not provide any substantive guidance as to the scope of liability. Therefore, need is to examine certain relevant judgments which have specifically considered the scope of state liability in relation to the tortious act of public servants. Let us begin with P&O Steam Navigation Company case of 1868. The court in this case made a distinction between sovereign and non-sovereign functions as the basis of liability. If the function is one that can be carried out by a private individual without delegation of sovereign function, it is a non-sovereign function and liability can be imposed on the government. On the other hand, if sovereign power or delegation of such power is essential for carrying out the act in question, the function is sovereign and no liability can be imposed. The test thus forms the basis of determining the liability. Now, the test laid down in this case is so broad that it confers wide discretion on the judge to characterize a function as sovereign or non-sovereign according to his will and pleasure. If he is inclined to do justice to individuals, he may interpret the term non-sovereign function widely and make the state liable. On the contrary, if he is biased in favor of the state, he may give a liberal interpretation to the term sovereign function and save the government from liability. However, the development of the case law in this area is interesting. There is a shift in the judicial attitude when India has changed from police state to welfare state. In laissez-faire era, when the government was concerned more with policing function than with welfare activities, most of the function exercised by the government of India were considered as sovereign function. Accordingly, defense functions, maintenance of law and order, administration of justice, matter incidental thereto, and also imposition and collection of taxes were interpreted as sovereign functions. As a consequence, in many cases the private individual did not get any compensation for huge loss suffered by him. Like in the case of Kasturilal, in 1965, the trader failed to get compensation from the government for the huge losses suffered due to the loss of gold kept in police custody because of the wide interpretation given to the term sovereign functions. With proliferation of welfare functions, a restrictive interpretation to the term sovereign function is being given. Accordingly, commercial functions, welfare functions, civilian functions of the military, etc. are all included in non-sovereign category. In the case of state of Rajasthan, which is Vidyavati, in 1962 opened a new trend in this direction. The multifarious activities undertaken by government in a welfare state involves not only use of sovereign power, but also the power as an employer. So, it is too much to claim that the state should be immune from consequences of tortious acts of its employees committed in the course of employment. Thus, Supreme Court in Vidyavati case held that in a democratic country, in order to meet individualized justice, the government also should be made liable for torts of its employees, just like a ordinary employer. To achieve this, the sovereign immunity should be kept at a minimum level. The court thus made a good move in this direction by restricting the sovereign immunity through the liberal interpretation of non-sovereign functions. It is suggested that the state can be sued by the citizens for the negligence of government employers in the course of providing welfare services. Traditionally, all acts of military employees in discharge of their duties were held to be sovereign function. But contrary to the earlier approach, now the judicial tendency is to include civilian functions of military in the category of non-sovereign functions, like transporting coal, machineries, vegetables, or carrying hockey or basketball team or officers from place of exercise to college. This is all considered to be non-sovereign functions. Over the time, the Supreme Court has also developed the principle that state was liable to pay compensation to its citizens for any harm suffered by them due to negligence by the bureaucracy or the police. The court have held that a claim in public law for compensation for contravention of human rights and fundamental freedoms, the protection of which is guaranteed by the Constitution, is an acknowledged remedy for enforcement and protection of such rights. The judicial attitude shows today the tendency to widen the scope of governmental liability through a liberal interpretation of non-sovereign functions. In the welfare state, the multifarious activity newly undertaken by the government are added by judicial interpretation to the category of non-sovereign functions. Besides this, the changed judicial attitude has restricted the scope of sovereign functions by including matters incidental to sovereign functions also in non-sovereign category. So friends, in this session, I have tried to briefly discuss the government liability for tortious acts of its servants. With this, I end my session and leave you with some basic questions which you will be able to answer with ease. Thank you all for watching this video.